Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Let's turn to another piece of the Trump trial in New York. This is a second ruling by Judge Juan Merchan on extrajudicial statements by Donald Trump that the prosecution is claiming amount to contempt of court. Previously, the judge had ruled that Donald Trump was in contempt 9 separate instances when he was discussing potential witnesses, including Michael Cohen, and making at least one statement about the juror or potential jurors in this case. He had fined Donald Trump $1,000, which is the maximum under New York law for each of those. Prosecution then subsequently asked the judge for 4 more counts of contempt. And interestingly, Kim, he accepted one of those, fined Trump another $1,000, and said he was trying to avoid jail time, and said that that instance of breaking the gag order in this case happened before his previous contempt ruling, so that Donald Trump would now be on notice, but also denied the prosecution's motion on 3 of these, including accepting the argument that some of these were Trump responding political speech to attacks from Michael Cohen.
Yeah, that was really interesting to me about this, because it seems to be a shift a little bit in the judge's view on this. You had 2 statements that the prosecution had brought forth, both of them, as you note, dealing with Michael Cohen. One of them, he said something along the lines of, look at all the lies that Cohen had in his last trial. Another one, he said, Cohen is a convicted liar. He's got no credibility whatsoever. This has been a big issue in the case because, as we know, Michael Cohen has been out talking to the media a ton, selling his side of the story, his version of events. And yet Donald Trump seemed to be hit with this gag order where he was unable to respond outside of anything official going on in the courtroom. The judge did indeed deny those 2 things, said that he could not prove beyond a reasonable doubt that they were not protected speech. He similarly threw out a charge that the request that the prosecution had made for some sort of punishment for a statement that he'd made about David Pecker at the National Enquirer, in which he just said he was a nice guy. I'm not entirely sure how that counts as witness intimidation. But he did, however, keep the one in which Donald Trump had been complaining that the jury pool in New York was overwhelmingly Democratic, and therefore suggested he was not going to be able to get a fair trial. And what really struck me too, Kyle, is if you read the transcript, how much the judge seems to almost be having buyer's remorse over some of this, because he continues to get asked by the prosecution team to go after Donald Trump. And he actually had a statement. He just said, look, the last thing I want to do is put you in jail. You're the former president of the United States. You could possibly be the president again. Incarceration is a last resort. It would be incredibly complex as well. It could disrupt the proceedings in this courtroom. It would be very difficult for the court personnel and the corrections officers. I really don't want to do it. And he was almost sort of putting out a plea to Donald Trump, like, please, please, just stand down. Don't make me be in this position. I think this has become an enormous side issue of this trial, but a big one nonetheless. And the judge is realizing its potential, if Donald Trump doesn't stand down, for it to escalate and really, as he said, disrupt the entire trial.
2 points I would make, though. One is that the judge made clear that if these $1,000 fines are not enough of a deterrence for Donald Trump to comply with the gag order, that the judge would, in fact, order some kind of incarceratory sentence, is what he had previously said. He said, at the end of the day, I have a job to do, and part of that job is to protect the dignity of the judicial system and compel respect. Your continued violations of this court's lawful order threaten to interfere with the administration of justice in constant attacks which constitute a direct attack on the rule of law. But Kim, let me underline a piece of what you said earlier, too, because he also said that he worried that any sort of jail sentence for contempt would have an effect on the people who have to execute that sanction, the court officers, the correction officers, the Secret Service detail, among others. I worry about them and what would go into executing such a sanction. That is from the transcript on Monday. And part of why I think that's interesting, Kim, is those same sort of concerns would hold over if we get to the sentencing phase of this. If Donald Trump is convicted, it would be very disruptive. And it's not even clear how it would work to have a former president of the United States who enjoys Secret Service protection in some kind of jail or state prison. So I do wonder whether there is a potential signal there, or maybe I'm reading too much into it, that if we get to a conviction, that the judge will maybe have second thoughts about that with this first-time offender and would result in a sentence like probation or something like that.
Well, it is good to see the judge acknowledge that this is an unprecedented situation and that he's dealing with issues that in many ways transcend his usual courtroom questions. You have a man who is actively running for the president of the United States right now. If you were to look at the polls, has a very good shot of becoming president again. And a man who has not just that schedule to maintain, but also, as you note, all kinds of security protections and concerns that do not attend most people who probably walk into Judge Merchan courtroom. So that's at least good, but I think it highlights for everyone the extraordinary nature of all of these judicial proceedings and why a lot of these trials were arguably very misguided. We have talked a lot about all of the charges that have been brought, whether by special counsel Jack Smith or here in New York or the case in Georgia. By the way, many of those are now getting delayed. But we have argued that because many of these charges were tenuous at best, it was probably much better to let the voting public make a decision about Donald Trump and his behavior as part of an election, rather than put the nation through all of this. And we're now getting to see the up-close consequences of prosecutors nonetheless deciding to go forward, and just how complex that is in terms of the logistics and necessities required for a fair trial in the middle of a presidential election.
One last thought is that delay that you mentioned, Kim. The January 6th indictment brought by Jack Smith is kind of tied up at the Supreme Court at the moment on whether there is some kind of immunity for presidents for official actions, and what in that indictment is official, what in that indictment is unofficial. But it also seems like there have been delays in the Georgia case and in the classified documents case as well. And so, Kim, maybe you can talk a little bit about those, but it is remarkable that when the Alvin Bragg indictment first came down, many legal analysts said this is a weak case. Wait for what's going to happen next. And now the only one of these cases that looks like we're going to get a result before the election is the Alvin Bragg case, which I think retains the same sort of weaknesses that were identified at the time, whether or not the press is really interested in talking about that or not.
Yeah, it's a really great point, Kyle. As you mentioned, we look at these other cases right now. The other big news is that you go to the other Jack Smith case, which is a classified documents case down in Florida. The judge there, we were supposed to have a May trial beginning. She has now indefinitely postponed the start of that trial because she notes all the many and continued and very thorny disputes that are still in front of the court that need to be ironed out prior to a trial actually beginning. And they range from issues that have to do with the evidence and what's been seen and the order of topics. It's a big stack of things that need to get sorted through. So we don't know if there's going to be a trial before the election, given the amount that needs to be sorted through, and given that this judge has also been very firm that she is not going to rush the normal course of a case, a somewhat unprecedented case, just because there are prosecutors that are trying to get things done before an election. Then in Georgia, again, just this week, a Georgia appeals court has agreed to hear a motion from the Trump team questioning the lower court's decision to allow Fani Willis, the district attorney there, to continue as head of that case after everything came out about a relationship she'd had with the special prosecutors she'd brought in for that case, Nathan Wade. He had a judge's order quit the case. The judge allowed her to continue. Now an appeals court is going to decide if that was valid. That could take some time. There are also still questions about what charges are going to be allowed in that case or not. The lower court judge threw out a couple, but there's still frustration on the Trump team over that. And then, as you note, the Supreme Court is looking at the third case, the Jack Smith case, that has to do with January 6th. So yes, we could end up where the only active case that happens here is Alvin Bragg's. And as we just discussed, it's a bit of a mess.